Thank you, Judge. This is a story not only about the negligent care of my client with his dogs, the tragedy of having a beautiful life lost in such a horrible manner, of having his wife also damaged, mauled, and other people as well. It's a story about what happens in a certain part of this city, in certain environments, and how law enforcement handles situations involving animals that are not always kept behind their fence and that bite people. We cannot tell this story without talking about animal control, Judge. Animal control services. It would be wrong on so many levels. Homeowners in this part of town, Judge, like my client and his wife, ordinarily don't have money to get security systems, to get dogs. That's their protection. It's part of the culture. And to get dogs that are strong enough and are able to give enough of an appearance to ward off criminals. This is how they protect their property, Judge. Many of these folks, like my client and his wife, don't have money to live like ordinary middle-class people do, Judge. They're poor. They also have limited education, so that the amount of information that we ordinarily expect of the average citizen in our community is not something they know about. Day to day, they have families. They look for work. They try and stay above water. There's testimony that my clients didn't have power at their house for periods at a time. They weren't staying there either sometimes. The dogs were left there. This not only reflects, it reflects to some degree a negligence when it comes to the animals, but it also reflects a lifestyle. This is how some people live, Judge. And this is understood, in this case, in an area of town we call the West Side. My client and his wife were not the only ones that kept these dogs. We know that other neighbors, including one close by, had other pit bulls. The pit bull has become a fixture, if you will, a sign of, among other things, security for some families. These are these dogs that were kept by my client and his family. You never heard testimony, Your Honor, that these dogs ever attacked their owners. There were children around these dogs. These dogs were family dogs. I cannot tell you the reason why this happened that day, except that there was some very similar conduct in at least 2 years before the incident, where these dogs had bitten other people. However, the city is linked to this whole tragedy for the simple reason that they were tasked not only with a job of impounding the dogs, but also with protecting the community, which is what they failed at. And that was part of the MO pretty much, Judge. They weren't concerned with that. They were worried about taking the dog in, and on occasion, they would spay and neuter female or male dog and would return them. We know that because in this case, these dogs were impounded, or at least some of the dogs, but that belong to this family, were impounded 3 times before the fatal incident. 3 times, Judge. And we have a pretty good idea of the kind of damage these dogs did to individuals that were lucky enough to walk away. Serious injuries, Judge. Animal control, I mean, where do I start? The state did its best to try and present a picture of an understaffed, undermanned agency. You know, 4 different, I guess, investigative officers on bites, I think it was, or something to that something of that nature. 4 such offices for a city as large as San Antonio. Wow. We were understaffed. We didn't have the manpower to handle and take care of the community. You know, Judge, if this would have been a situation involving a phone call that's missed, or, you know what, we lost our operator, you know, she changed jobs, or we haven't been able to hire help to get on the phone and receive phone calls, that's one thing. But there was a 2-year relationship with Animal Control Services. They impounded the dogs 3 times. So they had the time and the manpower to impound dogs. But they never took the time to follow up on what should have been done to protect the community. That just didn't happen. And the reason it didn't happen is because it was not part of the structure. They have these basically makeshift grades of bites, bite severity. You have mild, you have, I think, serious and severe, and I forget because these change depending on who testified and when from animal control. You know, severe was just more serious than moderate was. So that was the type of bite that required them to actively seek an affidavit. The next conundrum in this whole process, an affidavit that is required under the municipal code, which is an extension of the health and safety code, in order to begin a judicial process by which a court, generally a municipal court, determines that the dogs are dangerous, and therefore a whole new set of rules are judicially imposed. And those rules come from the code, the municipal code, 5-77, and I'll go quickly over what these requirements are, Judge. It expands on the language of Texas Health and Safety Code 822.042B, requiring that the dangerous dog, because of course this is after a court determines they're dangerous. Because in Texas, as I learned, and I didn't know, found out, it's legal to own a dangerous dog. It's just that the only way you can do that is if you follow the regulations, which are extremely strict, expensive, Judge, and overly restricted in terms of notice, checking the house before the dog is released in cases where they meet all these requirements. One, let's look at these. Dangerous dogs should at all times wear a collar approved by the department visible at 50 feet so that the dog can be identified as a dangerous dog. The department is authorized to charge the dog owner a fee to cover the cost of the collar, money. Expands on Texas Health and Safety Code 822.042B by requiring that the dangerous dog must be kept in an enclosure as defined in Section 5-1 of the Municipal Code. A structure to prevent an animal from being able to run at large. That's a definition. Enclosure means a house or a building, or in the case of a fence or structure, pen. The fence or structure pen must also have a minimum dimensions of 5 feet by 10 feet. Minimum dimensions. The fence or structure pen must form an enclosure suitable to prevent entry of young children and must be locked and secured such that an animal cannot climb, dig, jump, or otherwise escape of its own volition. The enclosure shall be securely locked at all times. The structure pen must have secure sides to prevent the dangerous animal from escaping from the enclosure. The structure pen shall provide protection from the elements for the dangerous animal. Notwithstanding the fence height restrictions of Section 6-2, the animal care officer shall have the right to require that the fence be higher than the 6 feet, which is the minimum to require in height. To require a secure top and or bottom be added to the structure pen if the need is demonstrated. These additional requirements shall be based upon the type of animal to be kept in this enclosure and its anticipated ability to escape. And we know from testimony that this was done because testimony was clear from the 2 witnesses that testified in February and April that there are dangerous dogs. that are kept under these conditions. Because I was incredulous. I didn't think it was possible to do this unless you got a lot of money, and we learned from testimony that it does happen. The owner also requires the dangerous dog to present to the department a certificate of public liability. That's $100,000, Judge, in coverage for any injuries caused by the dangerous dog. The insurance shall be kept in effect continuously and shall not be canceled unless the dog is no longer kept by the insured owner. Additional requirement: when the dangerous dog is taken outside the enclosure, it shall be kept secured by a sturdy leash of maximum 4 feet in length and maintain muscle in a manner that will not cause injury to the dog or interfere with its vision or respiration. The department is authorized to charge the dog owner a fee to cover the cost of his leash, money. It also adds that the owner shall post no less than 2 signs on his or her premises warning that there is a dangerous dog on the property. The signs shall be visible and capable of being read from the public street or highway. In addition, the department shall issue a uniform dangerous dog similar decal. Here's an official one, Judge. Understandable by small children, which shall be made available at cost to the public, adding such symbol and where decal must be displayed on or about the sign. If the dog does not have a registered microchip, the owner shall authorize the department to impose one. At the owner's expense, money, the dangerous dog must be spayed or neutered either by the department or at the discretion of the department by a veterinarian approved by the department prior to being released back to its owner. It's the only thing they did, Judge. And that was negotiated because it was too expensive for the family. They contacted my client's wife and said, "Come get your dog. Can you pay $700? There's no way." And she was ready to let him go, Judge. But I believe that her daughter or her children loved their dogs. They wanted them back. So she went back there and they bartered, Judge. And she was able to pay what she could afford and get the dogs back. But something else happened that was, I would say, criminal, Judge, on the part of animal control. They represented to her that spaying and neutering would be all they needed to do to get the dogs back, which effectively told them, absent any of this information, this is all you need. Take your dogs back, and you'll be fine. And that's how my client understood it. And anybody in her position, Judge, from her background and experience, would have understood that. And that's what happened here. The city went out of its way to affirmatively misrepresent what was necessary to make sure the community was safe. That's what they did when they did that. Oh, the owners must complete a class on responsible pet ownership conducted by an organization approved by the department within 2 months after the determination. And finally, the owner must allow an annual inspection of the residence where the dog is kept in order for the department to verify continued compliance with requirements 1 through 10 of this section. More frequent inspections may be conducted in response to specific complaints regarding non-compliance with this section. Here's the other thing. Before the dogs are released, on the assumption that all this is about to take place, the officers from the Animal Control Service must go to the place to make sure that everything has been complied with. The most that we heard was told to Ms. Schnieder in this case was, well, you know, try and keep them with a collar and make sure you tie them up. You know, that's not enough. Our expert testified that you cannot leave compliance regarding your own pets to the owners. You can't. Dog owners will do what they think they should do because they love their pets. It's universally understood, I believe, but it's actually a finding by our expert. You can't leave it up to them. So, with this history, Judge, the dogs go back to their home, and 2 weeks later, we have a tragedy. And so, additional problems with what we heard, and it must be said, Animal Control Services, Your Honor, did only one thing. They did it repeatedly. They took dogs, kept it for 10 days, and then returned them. When you hear them talk about their standards, if you can call them that, you learn several things about this organization. One is that there were no standards. or any kind of structure or directions within the department to ensure that an affidavit, which was necessary as per the ordinance, to ensure that that affidavit was completed. Ms. Abilene Schnieder, Schneider. I'm sorry. Ms. Snowden, the officer from the Animal Services testified. She had her own version of how this worked. In so many words, she said, well, the bites weren't serious enough, so we didn't need an affidavit. When Mr. Shannon Sims, the recently departed director who left after 2.5 years as a director, he took an early retirement, Judge. When he testified, he said that he was the person in charge of determining if there was going to be a process to determine through the court system the dangerousness of the dogs. But what did he say? He basically said, nobody brought me the affidavit. So we go from not needing to do the affidavit to, well, I never got it. That is the hole, Judge. That is the void. That's what was never done by the department. To add insult to injury, Judge, even assuming that this process would have been followed, because in their own interpretation of the statute, it's actually laughable. They decided on their own, even though there's no guidelines, nothing written, something that came from the city attorneys, been done like this for 10 years. When I asked Mr. Sims, he talked about how the process itself of determining the type of bite, it's something they've been doing for years. There's nothing in writing, there's no standards, really. Ms. Snowden testifies you need 3 bites before anything's done as far as proceeding with the affidavit. That's interesting because the 3rd bite here was fatality. Somebody had to die before somebody considered filing an affidavit. But here's the other problem. They interpret the person necessary to fill out this affidavit as the victim or a witness to the incident. They just made it up, Judge. It's not in the ordinance. And our expert testified, that's not what the ordinance says. A person prepares the affidavit. And somebody with the authority to notarize it then does that. That's all that had to be done. The people that were injured were visited by animal control. They were there, I would say, for at least an hour, taking a report, taking pictures. They did all that. They just didn't do the affidavit, even after seeing the type of injury. That's because there was somebody else tasked within the office with doing that. But we don't know who they are. And they just didn't do it. That is their interpretation of how the system was supposed to work. And they did it all with a straight face, Judge. When you consider in its totality the circumstances under which my client and his wife lived, their environment, their past experiences, and the fact that animal control had full knowledge of what was going on in this particular case, and I'm sure it happens everywhere. But there's been other fatalities too, Judge, but I can't speak exactly as to what happened there. We cannot separate the role of animal control with what happened in this case. My client has admitted his negligence. He should have done more. With his limited resources, there's evidence he was trying to patch up that fence as best he could. It's the best that he could do, Judge. He couldn't afford a new fence. It's the best that he could do. And nobody was there to make him do anything different. And he should have been. That's the problem. Somehow, it's what the state has done here. Go for the low-hanging fruit, Judge. Who's going to care if we prosecute them? How many people from animal control were prosecuted? What kind of investigation was launched to see if they were criminally negligent, Judge? Nobody. Nobody at all. In fact, we on the defense side had to dig out this information and realize what really happened here. Because in the ordinary sense, this would have been a situation where, well, you just didn't keep your dog the way you should have. You know, there's a history of this type of negligence. And so you got to just say, sorry, you didn't mean it. That's the one-dimensional version of this case, but there's a long history here, Judge. We know that dead dogs can't kill people. There is no question that at any point in time that any of the dogs that were impounded from this family were taken by animal control. Given the severity of and we didn't even have to go into the other bites, Judge. We only used the most recent one with the expert. That alone on its own, based on the expert's experience and the manner in which the law is applied in other areas of the country, which is pretty regular, including Texas, Judge, that would have required the judicial proceeding to begin with the affidavit. And it was not done. That one incident was enough to get it done. And so what the state is doing is, well, it doesn't matter. It doesn't matter if they return the dogs, because you still have a responsibility to take care of those dogs. Interesting. My clients were charged with the version of the statute that requires negligence to be proved, but not the dangerous dog version, Judge. These dogs were dangerous. And I don't like to say it because they're my clients' dogs. But they never charged it because to do so would have required them to admit that the dogs were dangerous, which would have required automatically to assume and admit that they should have been put through the process to determine through a judicial system that they were dangerous. If those dogs would have gone through that process, Judge, they would have been euthanized. There's no way this couple would have been able to afford that. All the requirements. I mean, who can, really? It's not only a matter of money, it's a matter of attention. Who really can spend the time to do all this, to keep dangerous dogs? I mean, this thing is designed in such a way where it's just not feasible to keep a dangerous dog, Judge. It's too difficult. And what the state has done is charged our clients with the negligence version, which does not mention dangerous dog. That's interesting. As if the dangerous dog, the whole issue, though, the whole subject of dangerous dog doesn't belong in this case, but it's at the center, it's at the heart of this case. And it's the reason why we brought forth this evidence with animal control, because there's a huge story behind this. The animals were dangerous. But all the state has to do is prove negligence. And oh my God, somebody died. So we got a 2 to 20 and they figure, well, it's a gruesome death, injury to others. Of course it's going to take care of itself. You were negligent, somebody died. That's what they did. They selectively picked the statute that was easy to prove with disastrous consequences. The 2 to 20 great range offense for the death of Mr. Nakada and the serious injuries to his wife. That's what they did. And they want us, they actually are going to argue, I assume, that none of this is relevant, Judge, with a straight face. None of that matters, Judge, because they were supposed to take care of the dogs and get the fence the right way they should, should have been done. If you look at the pleadings, they alleged that there were defects in the fence, one of which was the height of the fence. What height was necessary to keep a dangerous dog? Well, at least 6 feet, Judge. They didn't have that. Did they know to do that? Nobody told them. An enclosure, and I won't bore you with the details, the concrete part under it so the dogs don't dig under it, everything, this thing's like a security house. That was not what they had. But that was not expected of them. And nobody ever told them to do that. Just kind of leash your dog. And by the way, we're going to throw in, a spay and neutering, and you pay us so much the 3rd time, and you'll be fine. Somebody at the front desk told them this, Judge. This is the lack of regard and care that this organization had for the community. And Judge, don't take it from me. Testimony came in here from several different witnesses who are extremely passionate, frustrated, some surprised. Ms. Abilene, and I knew who she was because she was in a lot of recordings, and she was complaining in the recordings that we got in Discovery. In Spanish, her dog was attacked, and she would call the time, and they never showed up. They never did anything. She learned, apparently, from when I told her about what had to be done with dangerous dogs, she said, she opened her mouth, I didn't know that. I didn't know that there was a process. that has to be followed. She had no idea. You know, she's like, and she said that our clients were guilty, and they are, Judge. We're negligent. But she had no idea that animal control did nothing, and they could have done so much. They ignored her calls. Another lady came in and said that at least, I think somebody said 200 times, am I right? Somebody did. Somebody said 20 for sure. That they just wouldn't pay attention, Judge. They were ignored. That's what happened. And Miss Abilene said it. She was careful to express herself. She didn't want to get political. She said, I felt discriminated. She was, Judge, like everybody else was here. West Side, these people have their dogs all over the place. They have a whole bunch of pit bulls. Who cares? Who cares? We have the money and the time to take them in and pound them, keep them from 10 days, and then we give them back. It's all for show, Judge. At least that's the way they ran this office. The moment they had those dogs the third time, and the history shows, and it supports the charge for negligence, because the dogs were roaming. But at the point at which they had these dogs the third time, Judge, nobody had died. We wouldn't be here, those dogs would have been destroyed. And that's why it's important to mention to the court the level of culpability that this organization had and how it's part of this case. My clients were guilty. My client was guilty of negligence. There's no question. That's not the whole story. The city of San Antonio had an obligation, and they enabled this to happen by releasing the dog three times. They enabled it because they let people think this is enough. This is all we have to do. It's not like that doesn't happen. People have limited economic resources, Judge. Limited education. My client is working at Amazon now. He's been trying to make things happen for his family. He got his GED. You know, he didn't finish high school. He's a working man. He's got a spotty record, no question about it. But there's nothing to suggest that this man is cruel or that anything that happened was intended, Judge. In fact, they had a really good relationship with a neighbor, where this couple, this beautiful couple, came to visit. They knew them. And the dogs did what they did, Judge. This is what the story's about. It's a little wonder that the family of the deceased, his wife and the family, have filed suit in federal court, Judge. It just happens to coincide with our timing, but it's a little wonder. It's a federal lawsuit that alleges negligence and constitutional violations, Judge. There's no question that this office did not even have the training or the structure or the guidelines to carry on their duties. And it's hard to win these cases, Your Honor. We see how many cases that you win that involve civil rights, go to the Fifth Circuit and find a quick death. It's extremely difficult to win these cases. But if there's one that should win, it's this one. It's got holes everywhere. The more you dig, the more you realize there was no structure. Nobody was tasked with any jobs. Nobody ever followed out anything. And the act of returning two dangerous dogs, basically just let them loose in the community, Judge. What do you call that? I would say it's not even conscious indifference. It's cruelty, Judge. They didn't care. And we've talked about it. You think this happens in Abilene Heights? In the other parts of town where there's money? No. No, it doesn't. It happened here. This is a tale, a story that is unique to this part of town and to this family. But there's many others like them, Judge. What am I asking for? Your Honor, in assessing the punishment, which is entirely your ambit, it's your discretion. You take many things into account. You have wide discretion, Judge. This is not a civil litigation case. If it were, the concept of comparative negligence would be in play. And I haven't done torts in a while. It's comparative or contributory, where there's a percentage of negligence. Depending on who has more, somebody wins, or maybe they probate the damages. I don't know. So I'm not here to tell you to deal with this case on its face as if it's a negligence case. But I am asking the court to consider in punishment that the concept should apply here. It was not all their fault that this happened, Judge. City of San Antonio bears the blame, and the lady who lost her husband and her family testified to that. And they're right. The city failed them. And in designing your punishment for my client, Judge, I'm asking you to consider, in terms of equity and fairness, that whatever it is my client deserves in punishment should be determined by taking into consideration the enabling, the malfeasance, the criminal conduct of the city. Because if the city would have followed the rules, forget the first 2 times, maybe just the last time, these dogs would have been dead. Dead dogs can't kill people, Judge. And it was just by a sliver, just that one moment when Abilene Schnieder's daughter, we love them, we love our dogs, she went back. It's the only thing she understood, Judge. She got the dogs back. Otherwise, those dogs would have been dead. But not because they were supposed to be dead, but because my clients could not afford more. I hope, I wish that there's success for the family in this civil litigation. Because this kind of thing has been going on for a while, Judge. You read about it, about dogs biting people. And generally, it's in a certain part of town. And that's what happened here. I'm asking that you consider, Judge, whatever level of fault you can grant my client probation. He's never been sentenced to prison. He's got some problems. You know what his history is. If Your Honor feels that probation is inappropriate, then we ask whatever prison sentence you apply, Judge, that you discount in your own way the length of that sentence based on what people from animal control should have been sentenced to, because they share a great part of the blame. If not half, at the very least half. I would say it's even more than half, because they were in the position. They were the experts. They knew how this worked. They were in a position to protect the community and to advise and counsel these people on how to do things right with their dogs. They didn't even have the time to show up, Judge. They have a hand on it because they had the dogs in their possession, Judge. Those dogs were safe. The community was safe when they were in their possession. And they just turned them loose. That is a criminal act. And it's possible that nobody will ever have to face criminal charges from the office to City of San Antonio. DA's office did not go there. They just picked on them. Low-hanging fruit, Judge. Whatever sentence you desire to impose on this man, we ask that you consider that as mitigation. That's what we're asking for. This did not have to happen, Your Honor. It did not have to happen. It's an extremely sad, tragic event. But there's a history behind it. And when you consider all the facts, we believe that a sentence, whatever sentence you want to give, Judge, should be mitigated, reduced by the amount of fault on the City of San Antonio. Thank you, Judge.
Thank you, Judge. May it please the court, counsel. Judge, I'm going to do my best not to cover the same ground as Mr. Azotolidis. So I'll be looking at my notes to make sure I don't forget the main points I wanted to go over. I will begin with building on the animal control argument, since that was so well put just now. A couple things I wanted to point out is that under the statute, under Texas Health and Safety Code 822.0421, any witness can make these affidavits. It says that clearly. And I bring this up because what's become clear to me is that animal control was using the statutes and interpreting it in such a way to minimize their own work. Why? Because, as Lieutenant Snowden so clearly testified to, they were very much undermanned in an extreme way. Not only that, Judge, the use of the affidavit as a tool to reduce their work comes in addition to their interpretation of this severity of the bite being necessary to trigger the dangerous dog process. Judge, when you review the statute, severity of the bite is not in there at all. Okay? This is a situation that could have been easily determined on any of these investigations, but as I alluded to earlier with the Lieutenant Snowden, she's throwing up her hands. She's saying, what are we supposed to do? We only have 4 people for the city who are their bite investigators to get these affidavits that they deem required for them to move on this dangerous dog process, which once again I suggest is not required under the statutes. But only 4 for the whole city. And Lieutenant Snowden says, we only have 44 people in our field office total. What are we to do? Judge, we have alleged, and we had pretrial hearings alleging this is governmental outrageous conduct, but as I've come to learn, this wasn't a one-time thing. This wasn't a common pattern. This was animal control's day-to-day reality. As I believe Lieutenant Snowden, perhaps Director Sims when he testified, said, we have 300 calls a day. What do you want us to do? It's that attitude that just rang out to me so clearly whenever any of the animal control officials testified. We're doing the best we can, is what they're saying. This is what we got. And here we are. And in this case, with Abilene, you heard her in her interviews with the detective that she once again said to the ACS officials after the January bite incident, where there was a negotiation from animal control saying, well, if you spay and neuter, well, if you spay King, we'll waive the fee. And if you neuter Snow, we'll give them back for a reduced fee. And things should be good. What prompted this conversation? Abilene asked them, what do I need to do to stop this from happening? She was begging them, tell me, please. And what did she get in return? No documents, no instruction, nothing about any of these requirements that she should be doing. Nothing at all. And here we are. Judge, this is a negligence case, as you're well aware of. Ms. Schnieder has no convictions in her history. No misdemeanor convictions, no felony convictions, nothing. As you heard, she's currently under a brand new indictment that was just filed in Medina County from a November 2022 incident, which is a state jail felony. She's being alleged to have identification of 5 items or less. That is what's pending. But Judge, to make clear, no convictions in her life, none. Also, because of this incident, of this tragedy with the Nahara family, which is just so horrific, they had a CPS case started. And Judge, a 1.5 year CPS case, I can tell you, is extreme scrutiny of the type of people Christian and Abilene are, their ability to parent, and how they live their day-to-day life. Every part of their life is dissected and put under a microscope. And should they fail in any way, the government will terminate their parental rights. No doubt about it, especially when there's a criminal case pending where prison is possible. Okay? And as you heard from their therapist, Abilene was a model client, showed remorse from the beginning, never faking it, was compliant at all times, was successful. Sounded to me, Judge, that she couldn't have been more engaged, more truthful and honest, and ultimately, as you heard, the impression of her was that she couldn't have been better, even helped the other members of the group. And what was the final order, as you will have in front of you, Judge? Christian and Abilene were made joint managing conservators of their children. Okay? However, because of the way CPS operates, the children were made to stay with grandparents because prison is a possibility in this case. And once again, Judge, reiterate, we have applied for and we are asking for a term of probation for Abilene Schnieder under any terms the court deems appropriate, honestly. She would like to be there for her children and her family, and I'm suggesting to the court that getting through a CPS case under these circumstances is extremely difficult. And the fact that they did it, and weren't just made possessory conservators, but joint managing conservators, speaks volumes of their quality. Next, when I received this case and looking through all the discovery, and then again listening to the witnesses, one thing that really bothered me and I was concerned with is it seemed to me that Abilene and Christian were instantly blamed for any pit bull problems in the area, in their neighborhood. Now, I felt pretty sure that there are other pit bulls loose in that West Side area, and I was worried that Abilene and Christian, because of having poor relationships with their neighbors, they were just getting the blame no matter what. But we had, I believe, Mr. Fernando Esparza, if I'm not mistaken, came in here and testified that he was having problems with 2 loose pit bulls, which I believe he said were always loose in the street. And I said, where were those pit bulls from? He said, they're from the house with the 6-foot chain link fence with the tow truck in the front. That's where those pit bulls are at. Judge, that's the same street. It's the same street. It's just a few houses down. And in fact, I think any suggestion that Mr. Esparza doesn't know what dogs he's talking about, I think is a bit ridiculous, because the house he pointed out is the house he looks at every day, across the street from him. Across the street to the left. He sees the tow truck and that 6-foot fence with the big beware of dogs that he told the court had 2 loose pit bulls all the time that bothered him. Judge, you have the photos in front of you of that house. It looks the same as the Google map in November of 2022, which was a bit before this incident in February, but I believe the same as it looks now. It hasn't changed. It has the same sign as beware dog, the same tow truck, everything. Judge, all of those witnesses complaining, certainly much of that was true. I have no doubt about that. But not all of it. Not all of it. I believe anytime you see a dog or you see your trash can turned over, well, it had to be Abilene's dog. It got to that point. And I'm suggesting to the court that's just not the case. Critically, Judge, and I think it spoke to me volumes when Abilene and Christian's neighbor, Ms. Sylvia Cerna, came and testified. Miss Angie's daughter. Miss Angie had her mother, Miss Cerna's mother, had a great relationship with Abilene and Christian. And Miss Cerna wanted to come here on her own to tell the court, in her own words, that in her opinion, the world wasn't getting the full picture of what Abilene and Christian were like. The good things that they did when no one was looking. Helping her mother, her elderly mother. Helping her with Christmas lights. Being good to her all the time. Miss Cerna said, I visited my mother often. Never had a problem with the dogs. Ever. And she may have been a neighbor interacting with the dog most of anyone you heard from. And she's not related to Abilene or Christian. And she's friends with the Schnieder family. You can see how this is hurting her. This situation that's been created that we find ourselves in. Judge, this case is a tragedy that I feel certain could have been avoided, but for animal control's policy and practices at the time. And most importantly, the direction they gave my client of what to do. They said, spay and neuter the dogs, it'll be fine. Put them in a harness, it'll be fine. Did they come and check her fence, the height of the fence, which is part of the requirements? No, nothing. My client felt that she was doing what she was told to the letter. That's why I think at first she had a problem with saying, this is your fault, you did this is intentional. I think what all of that is from is Abilene feels so strongly that this was not intentional. She did not want this to happen to anybody. Of course not, this is awful. This was negligence, and she's acknowledged it, Judge. She's pled guilty to her role in this. But I asked the court to look at the big picture about how we got this, the type of people that they are, as you've heard from the witnesses, especially Ms. Serna, who has, not related, just wanted to give the court the facts and grant Abilene probation. Thank you, Judge.